who is on afraid of the committee. He's member of parliament, but an unknown member. But we have allowed him to be present because he applied to be present and was given consent by the Speaker to be present in this committee. He will not be asking questions. When you introduce yourself, I will allow you a minute to give a few remarks.
Thank you, Chair and members of the JLAC, Lady Justice Kome. Chair, my name is Abdul Rahim Dawood. I'm the Member of Parliament for North Imenti in Meru County, and I'm pleased to say I want to thank the JSC for nominating Lady Justice Martha Koome, who comes from my constituency of North Imenti, and we are very proud of her. Thank you, Chair.
Very well. Judge, feel comfortable. Is there anybody else? Judge, feel comfortable and welcome, and introduce yourself and any staffers that you have.
Thank you very much, Chairman and honorable members of this august house. My name is Martha Koome. I'm a judge in the Court of Appeal and a nominee by Judicial Service Commission for the office of the Chief Justice. I worked here with colleagues. I will ask them to introduce themselves because it is difficult to see them. I didn't bring my glasses.
Thank you, Chairman. My name is Patricia Nyaundi, Advocate of the High Court of Kenya and Senior Counsel. I thank you for the opportunity of sitting here with Justice Martha Koome.
Yes, I also have Roslyn Kabata, who is my mentee, yes, a lawyer, an advocate, working with the National Council on the Administration of Justice.
Yes. Good morning, honorable members, Honorable Lady Justice Martha Koome, senior colleagues. My name is Roslyn Kabata, an advocate of the High Court of Kenya and a program officer at the National Council on the Administration of Justice. I'm proud to be here. Thank you.
Good morning, Chair. Thank you, Chair. My name is Richard Otene. I'm a researcher in the Office of the Registrar High Court, and come here to represent the judiciary. Thank you.
Yes.
Welcome, FIDA officials who are on the gallery. Welcome also. Karibu. Maybe you give your names, give the officials so that we know you. Okay, karibu, Nancy.
My name is Honorable Lilian Maura, founder of FIDA.
Karibu, Lydian.
My name is Amululu, member of FIDA Kenya, having served as a treasurer to Honorable Martha Koome. My name is John Mohammed.
Yes.
I'm an advocate, I'm a senior counsel, and have been a member of FIDA and a friend of FIDA for very much from the time I started practice.
Welcome, feel welcome. Asante for coming. There's one more.
Good morning, members. Good morning, Chair. My name is Annie Mary. I'm a senior of FIDA.
Very well. Karibu.
Chair, with your permission.
Yes, Mheshimiwa.
Two preliminary issues, Chair. One, you have disposed of the presence of Honorable Rahim. He has explained this here with permission of the Speaker. That I'm satisfied with. But number two, in terms of Order 90 of the Standing Orders, Chair, allow me to declare my interest. Although Lady Justice Koome is my junior in the profession, but I wish to state that I served with her for a very long time on the Council of the LSK. Also, like myself, we are founder members of East African Law Society, and to do that, we travel a lot to Kampala, Dar es Salaam, Zanzibar many times. So that's the interest I have. So if I ask few questions, you'll understand why.
Well, that does not necessarily conflict, because a lot of us have had interaction with the judge, either in practice or the corridor, and as a judge also. So I don't think that will be influenced in any manner, because we will be objective in our questions. Very well. But it is entirely up to you subjectively. If you feel some matter you don't want to ask, it is entirely in your discretion. So, Judge, before we begin, in accordance with the Constitution, I think it is Article 166, your nomination went through JSC, went to His Excellency, and then through Parliament, it was remitted to this committee. Right from the outset, I want to state that we are not going to interview you. We are not interviewing you. We are only considering approval constitutionally and your general suitability. And the procedure, we may go through the procedure, arriving at the decision of your nomination. We have a folder with the material that yes. The material that went to His Excellency requesting to appoint you. And here we congratulate you. It is not an easy journey out of all the candidates for you to get nominated and mark you all the candidates that were shortlisted, qualified. But you are picked among the qualified number. So the material that went to His Excellency and then forwarded to Parliament contains what I may consider a certificate by the commissioners, the 8 commissioners in JSC, and in their communication they state, members, if you have 14, docket 14 in the folder. At the conclusion of the exercise and pursuant to Article 166, 1A, and Article 172, 1A of the Constitution of Kenya, as read with Section 14, Part 5, First Schedule of the Judicial Service Act, the Judicial Service Commission recommends the Honorable Lady Justice Kome Martha Karambu, ID is given there, for appointment as Chief Justice of the Republic of Kenya. That is a communication, and all the documents are with us. We will be running through some of them, some of the documents in our questions. So it is the mandate, therefore, donated by the Constitution through the, I think it's the Public Appointments Approval Act. So we are required, therefore, to refer to a limited mandate. Our jurisdiction is limited under Section 7 is limited to 3, as I stated them. A, the procedure used to the arrival of the decision on you. 2, any constitutional or statutory requirements relating to the office in question, and 3, the suitability of the nominee for the appointment proposed, having regard to whether the nominee's abilities, experience, and qualities meet the needs of the body to which nomination is being made, that is the judiciary. Therefore, that is our limited mandate in those 3 areas, and the word shall is used at the opening of section 7. So we don't go beyond that. We are limited to that. These are mandatory. Even if we appear to go outside, matters must be pegged to these 3 jurisdictional areas. I don't want to put straight my questions here. Yeah.
I, Martha Karambu Kome, do swear that the evidence I shall give before the Departmental Committee on Justice and Legal Affairs shall be the truth, the whole truth, and nothing but the truth. So God help me.
Please, Judge, very briefly, give us a few remarks on your resume, professional resume,
Yes.
and any other related matter in 3-4 minutes.
Okay.
If you can, briefly.
Thank you very much, Honorable Chairman and the honorable members of this august House. My name is Martha Kome. I'm a judge in the Court of Appeal, where I also end the criminal division of the court. It is indeed with utmost humility and gratitude to the Almighty God and to the people of Kenya that I have this opportunity that I've been given to present my candidature before this august House upon having been nominated for the office of the Chief Justice by the Judicial Service Commission. I have 33 years of experience as a practicing advocate, as a judge of the High Court, and as a Court of Appeal judge. I studied law at the University of Nairobi, graduated in 1986 with a bachelor's degree of law. I proceeded to the Kenya School of Law in 1987 and graduated with a postgraduate diploma in law in 1987. I was admitted as an advocate of the High Court of Kenya in 1987 when I started practicing. I bring to the office of the Chief Justice leadership skills that I've gained over those 3 years, where I have worked as a patriotic Kenyan in transformative leadership. I joined the Law Society Council, and we were actively involved in the early 90s with the struggle, lobby, and clamor for constitutional reform. For also institutional reform like the independence of the judiciary. I was also involved as the member of FINDA in the struggle for all reforms, and I'm very, very proud of the plethora of laws that have now come into effect to protect the family and to protect children of this country. I'm proud to be associated with the Constitution of Kenya 2010 because I participated in all the major discussions, in all the major conferences, from Kamukonji to Fungamano to Bomas of Kenya, up to when we had the 2010 Constitution promulgated. I've also experienced working in the region with the East Africa Law Society, which we founded as the honorable member for Kisumu stated. We were in the Council of the Law Society that founded the East Africa Law Society and were involved in the conversations that led to the creation of the treaty and the East Africa institutions such as the East Africa Court of Justice and the East Africa Law Society, which promotes regional integration and cross-border practice. I've also participated at the Africa region, where I served for 5 years as a commissioner at the African Union. I have experience internationally representing Kenya as a delegate to major conferences, world conferences, as a delegate. I'm an accredited trainer by the Commonwealth Secretariat. I've authored a book on gender-based violence, which is used as a benchmark to train judges and magistrates in East Africa on gender-based violence. I'm also an accredited trainer by the Institute of International Justice from Malta on human rights. So I bring a wealth of experience from practice, practicing in the courts all over Kenya, representing people especially struggling for good governance and rule of law. In my early days as an advocate, I did not just focus on making money, but how we could improve governance, how we could enhance access to justice. Therefore, I represented political detainees. I represented persons who are charged with politically instigated offenses like treason and illegal meetings. In 2002, I was invited by the judiciary, then I was the chairperson of FIDA, to join a committee called GJ Ross, and together with judges and other stakeholders, we developed a blueprint that guided the reforms in the justice sector that are now being implemented in the various strategic plans of the judiciary, the office of the ODPP, and even the prisons and the police.
I do not want to interrupt you.
Yes.
I think that is sufficient for us.
Okay.
After all, it's a repeat of what some of us saw on the television when you are before the Judicial Service Commission. I think that is enough so that we save time and be brief. I want to open the questions, but let me give you some areas that I would like you to briefly cover, and you can do that straight away before I draw questions to members. Generally, we would like you to give the nation your vision. Your vision for the judiciary generally, particularly in improving the relationship between the judiciary, the other two arms of government. Again, bear in mind that there are complaints on funding. There are also Parliament also felt that there was overbearing conflict, possible, potential conflict, when the issue or observations in Wabora case, you remember Wabora case? That judges should very, very sparingly issue orders injuncting Parliament. Also bear in mind, I'm sure you are fully conversant with Article 259, 1D of the Constitution that obligates you mandatorily when interpreting the Constitution. You must do it in a manner that contributes to good governance. I'm stating this so that you bear also at the back of your mind the advisory that was issued by your predecessor. The reflections on it, a reflection. We're seeing on it, looking at it critically. Potentially, it was possible to cause some disorder. We were happy, Judge, recently when we saw the three arms of government in the State House issuing some directives on COVID protocols. We saw the speakers of Parliament, His Excellency was there, and then we saw the acting Chief Justice. She was there, and they issued a joint communique on the COVID protocols. That is the sort of relationship I'm asking, that you tell us the way to go about it. And finally, what help? That is crucial. Because your voice could be heard through this very critical oversight committee, GLAC. What help or assistance you would like to be afforded to you by help that you, or assistance you would like afforded to you or the judiciary through this committee, which is the Oversight Committee on Judiciary. Maybe you comment on those briefly. Briefly, if you have marked them, briefly where you can, and then I'll draw questions open to my colleagues.
Thank you very much, Honorable Chairman. I will start with the vision, because I have a vision for the judiciary, which I have nurtured for many years. As you know, I have applied for this position. I applied for the Deputy Chief Justice in 2011, and I also applied for the Deputy Chief Justice in 2016, and now I felt I'm ready for the office of the Chief Justice. My vision for the judiciary stems from what is in the Constitution. The Constitution is a very progressive instrument that requires that the administration of justice is always responsive to the needs of Kenyans. Therefore, my vision is an independent judiciary that is accessible, that is efficient, that is responsive to the aspirations of Kenyans. This can be done through looking at what we have already in place. We have the people who serve the judiciary, the human resource capital register, to ensure that that register is completely aligned. The job description of every judicial officer or staff is defined, and there are deliverables, and there is accountability. Honorable members, judiciary does not operate as an island. We are independent, and thankfully, the independence of the judiciary is ring-fenced in the Constitution. It's secured in the Constitution that in terms of our decision-making and hiring of staff, we will not be under direction of any person or any authority. And that is known to everybody who is implementing the Constitution, that they cannot interfere with the decision-making authority of the judiciary. However, we are accountable to Kenyans in terms of the service delivery. Service delivery is a shared responsibility. Judiciary, as the custodian of justice, is at the center of the social, economic, human rights protection, and the development, national development of the country. We cannot deliver this alone. We require the support of the legislature when it comes to allocation of budgetary resources that will enable the judiciary perform its role. We require also the executive, because if we are talking about criminal cases, the police have got to investigate the cases properly. The Office of the Director of Prosecutions has to do its bit. The stakeholders, the advocates who represent the litigants, they have to do their bit. Therefore, honorable members, this is a shared responsibility, because I am aware you are also inundated by complaints from your constituents who are trying to access justice, and justice is delayed. Therefore, this is a shared responsibility. We have to work together. We have the National Council on the Administration of Justice that is supposed to bring together all the stakeholders at the table so that we can discuss the challenges. It has been realized that passing the buck does not work, because what the Kenyan want is services. They do not just want to hear who is not doing what. They just want to know when they file a case, they will be sure that within a defined period of time, they will get justice. So it is of utmost importance that the judiciary should work together with the other arms of government, which I call interdependence. But when it comes to interdependence, it has not been defined in the law. I look at the Intergovernmental Coordination Act, which defines the relations between the national government and the county governments, complete with a mechanism of how to deal with stalemates and disagreements that occur. But when it comes to delivery of justice, the services, and we are all intertwined, we are actually a chain, there is no organ like that can help us deal with the stalemate. But we are happy we have the NCAJ, which is thinly anchored under the Judicial Service Act. What I would recommend, we work together and come up with a bill, an act of parliament, NCAJ, complete with an organ that can enhance this kind of working relationship, and in the event that there is a stalemate, this body can deal with those conflicts. Chair, you asked about the interference of the judiciary with the mandate of the legislature. Indeed, the Constitution gives each body the mandate, and we are supposed to work with complementarity when respecting each other's area of operation. The courts give injunctions or give declaratory orders, but this is done with utmost restraint because it must always respect that lawmaking, the mandate of lawmaking is for the legislature, and they cannot be impeded in their work unless they have gone outside the parameters that are provided for in the Constitution. That is when the court is given powers of judicial review. I think that is, yes.
Before I had said that was the last, before I threw the questions to the floor, but I want you to be aware that there are certain communications and documents sent to us from 11 number parties, letters, documents. We have an affidavit objecting to your nomination from Karifa. You have seen it? It's in the file. And then two, we have Nelson Harvey also objecting. Let me read the objections first. Harvey, I have Khalifa, Harvey, and then we have another objection from Stephen Owako. Yes, Owako, Stephen Owako, and another objection is from James Kimadi Kibuja concerning some school or something. And then, happy for you, you have 7 supporting documents. You have support from Dr. Dedia, Democracy Trust Fund. You have support from John Rujikanya. You have support from Kenya Women Finance Trust. Another support comes from Alexander Kireria. You have support from Jared Nyachiro. Another support from International Commission of Jurists. That is a vital body. And lastly, you have support from Miss Lilian Wakenya Mwaura. Suppose the nomination. So, if you can comment perhaps briefly on the objections. The support is okay, we have it. We have more, right?
Yes, thank you, Chair.
And bear in mind that some of these objections, we are aware of them because we saw you comment before the Judicial Service Commission on them, Khalifa,
yes,
Harvey, this other Oako, you commented on them. So just repeat, please.
Yes, thank you, Honorable Chairman. I'll be very brief in the comments. In regard to the objection raised by Mr. Karifa, this is the 3rd time he is raising the same question regarding a hearing of an application that was filed on the 25th of August 2017 regarding the repeat of the presidential election. An order was issued the same day on the 25th of August by the High Court, declaring that all the returning officers and their deputies were illegally in office. What the implication was is that the next day, the repeat election of the president could not take place. On the 25th was declared a public holiday, but I was in Nairobi together with the bench that I was sitting with in Mombasa, Malindi. We were supposed to be working that week in Nairobi. At about 3:30, I received a call from the registrar of the court, Mr. Serem, informing me that the president of the court has certified an application urgent and I'm required to be part of the bench. That was to hear that application the same day because of the urgency. I made my way to court, arriving at about 5. I found the Honorable Mr. Justice Githinji, who was the presiding judge, and the Honorable Lady Justice Fatuma Sishale, who was also on the bench. We proceeded to court, and we had the application ex parte due to the exigencies of the time. We gave an order of stay of execution of that order, meaning the presidential election could go on because of the national importance of the matter. And that decision was later on confirmed by the Supreme Court when the Supreme Court was hearing the dispute over the repeat election. They agreed that the High Court had no jurisdiction to hear the matter, and I put it in the replying affidavit, which I submitted to the court, to this honorable August House, with the judgment of the Supreme Court and the particular paragraphs where the court made that ruling. As regards the objection by Mr. Harvey, he has reiterated the same case, and he has gone on to raise another case involving Iran supplies and general contractors who are involved in the allegedly having supplied maize to the Sirius Board, and they had obtained a decree to be paid some money. The Sirius Board had appealed and found an application for stay of execution. So what came before us, a bench of 3 judges, Justice Githinji presiding, the Honorable Justice Maraga, and myself, was an application for stay of execution. Applying our own discretion as judges, we were of the view that it was necessary to issue a stay of execution to stop the Sirius Board, which is the National Strategic Food Reserve, to not to pay the money until the merits of the case was heard. Honorable members, you are aware that this matter has gone on, and the directors of the Iran have been charged of fraud. They have been convicted and sentenced to serve many years in a criminal case. And this decision goes to show the importance of a timely judicial intervention that stopped the country from losing a lot of money. The other objection that was brought to my attention was by Mr. Nundin Nolani. I haven't received one from Mr. Wako. I don't think that was served on me. It is 6 o'clock last night. I received one from Nundin, but he had complained also to the Judicial Service Commission. I had responded. It is a case which was before me when I was a judge in the High Court, and he has misread this House to say that decision was appealed against. It wasn't my decision, it was a decision of another judge. So he has deliberately misread this house, and I put it in an affidavit.
You have received another support from Federation of Women Lawyers of Kenya. We have their support here. I don't know whether it's accurate to members. You can, fine, very well. Then, lastly, are judges, magistrates, Supreme Court, at all levels, the judiciary, are they always right? Objective.
Thank you very much, Honorable Chairman, for that question. That's why we have the appellate system, because magistrates, judges can make an error. They can see a matter differently. They can misapprehend some facts. They can misapprehend the law. And that is why we have the appellate system for somebody who is aggrieved to file an appeal rather than file a complaint, because the complaint will not help. If there was an error, it should be corrected by the appellate court.
Members, I'm sorry, I've taken quite a bit of your time. Now, can you, questions, any comment or question? Yes, Mheshimiwa Aruoch.
Thank you, Chair. Chair, I've heard the Honorable Kome decry the lack of legislative intervention in resolving conflicts between the three arms of government. And I agree with her on that. But looking at how our system operates, conflict between the three bodies will continue to occur. In the absence of legislative interventions, where is the diplomacy, the finesse, and the firmness in Justice Koome that will help in resolving these conflicts?
Thank you, Chair. Mine are just concerns. One, I know we are still in the process and it's not law yet, but we've taken inputs. We have inputs from JSC. May I know your take, Justice, on the BBI, particularly on the judicial reforms that are contained therein? We have the ombudsman being proposed. What is your take on this? Another concern, alive to the provisions of Article 160, I still want you to state your intended, or how you intend to relate with Parliament, and particularly this committee. I'm asking this because in the past we felt like we are funked as official after your concerns are the concerns of this committee. And if we find things being done through the media without even anything being mentioned to this committee, we feel we are not regarded as part of the judicial. So how do you intend to relate to this committee? And lastly, as you've been the chairperson of FIDA 2 times, maybe you can tell us at least one landmark achievement that showcases your leadership skills. Thank you.
Take those before we mix them up. Take the Aruoch, Mheshimiwa Aruoch on diplomacy, and then Ombudsman and the BBI, from Mheshimiwa Kamote.
Yes, thank you very much for those questions, honorable members. I want to assure Honorable Aruoch that I am very firm. I have been in leadership positions a significant number of 33 years, about 20 years I've been in leadership positions, leading organizations, and also in the judiciary. I've been a presiding judge in Nakuru. Those days it was a very huge jurisdiction, all the way from Maralal. There was no high court in Naivasha, Nyahururu, Kitare, Kericho. I covered all that area, opening mobile courts in the north. So I am very, very firm as a judicial officer. I'm also very good in negotiations, and I'm a peacemaker. I will employ every skill that I have. I am a people's person, driven to get results in all the things that I do. I work with the results in the beginning and work towards achieving the results. So you will be interacting with me if I'm given the privilege of being the Chief Justice by this august House. I will be consulting whenever it is necessary. The Honourable Member asked about the BBI, and I'll be very shy to say anything about that process because it's a live matter in court. It's what we call sub judice, and the law forbids me from discussing it, but we are not we are not opposed to reforms in the judiciary that enhance the access to justice and make the judiciary more efficient to the Kenyans. As we are speaking, the Judicial Service Commission is mandated to deal with complaints about judges because of the independence of the judges and because of the independence of the institution. And as it is now, nothing stops the Judicial Service Commission from advertising for the best person to apply to be employed as the ombudsperson of the judiciary, to receive complaints and help the JSC deal with the complaints. But that mandate lies under Article 160, as the Honourable Member has said, with the Judicial Service Commission. This committee is of utmost relevance and importance to the judiciary because this is the committee that examines and approves the budgetary allocations to the judiciary. The budgetary allocation is central to the work and the programs of the judiciary. We cannot consider you functus officio at all. If we consider this committee functus officio, it means we have broken a link and we cannot be able to serve Kenyans efficiently unless we work together to look at the resources that are needed for the judiciary to be able to implement the programs and ensure that justice is rendered in all corners of this country. Honourable members, you know the average distance between a court and the people is 175 kilometers. You can imagine if somebody's rights are violated, they will take a long time to access justice. So we need to work together to reduce that distance to about 100 kilometers and to be able to serve Kenyans. You don't just need a court, you also need police stations.
Jurisdiction of the Supreme Court. We all know that Supreme Court is a creature of 2010 Constitution. And there have been two schools of thought, that Supreme Court's jurisdiction is fairly limited, but it's as if the Supreme Court has been trying to crawl, to expand its jurisdiction, whereby it is ending up entertaining all kind of matters. And I think even having that in mind, although we should not comment about it, the proposed BBI is trying to say like election petition, apart from presidential, should actually go up to the Court of Appeal. So I want your comment about that, whether in your view, to what extent may be, if you are we approve you and you are appointed, and you'll be the president of this important institution, what is your view on jurisdiction? Second point is about also the tribunals. We know we have a lot of tribunals. I think that's a plus in the whole country. And also we know from 2010 Constitution, tribunals were put squarely under the judiciary. And like that before, they were under the executive and the ministers. And we also know, because we are also practitioners, quite a number of tribunals have not been operating. Some have no chairman, some have no proper budgets. Yet we know their role, which they play in the dispensation of justice. What are you going to do as a Chief Justice to ensure that these important tribunals, they are fully operational and they are not like an appendage of the mainstream judiciary? Thank you.
Judge, you can take two more, or you want first to answer those? I don't want to. Okay. Use the mic.
Yes, I will say something about FINDA. We were asked whether we have anything to show for the existence of FINDA and my life there in FINDA. I would like to say FINDA plays a critical role. It has helped this country in law reform, formulating the laws that protect families, offering pro bono legal services to indigent women and children so that they can access justice. And while at FINDA, we did landmark cases which went all the way to the Court of Appeal to declare rights of women, and they were used during the constitutional review process to inform the rights that are already entrenched in the Constitution, and those cases are reported in the Kenya Law Report. And then I was asked about Article 10, which deals with the national values and the principles of governance. And I want to say these are the principles that are applied in the interpretation of the Constitution and also in the interpretation of the law. These are the ones that guide the judges. They are the ones they refer to all the time to ensure that the decisions that are made by the court engender these principles of patriotism, nationalism, unity, devolution of power, non-discrimination, respect for human dignity, equity. These are the principles we apply on a day-to-day to ask ourselves whether the matter that the decision that we are rendering is actually engendering the interest of Kenyans by including these principles, whether we are actually perpetuating these principles or we are not following the Constitution. So these are our guiding principles. And then the member also asked the question about equal opportunities that is enshrined under Article 232, providing equal opportunity, providing competition, considering issues of gender equality and issues of ethnic balancing are principles that are enshrined in the Constitution. And I want to say Judicial Service Commission, as consciously looking at what they have done, employed the principles of gender equality. if I am privileged to be approved as the nominee for the office of the Chief Justice, for the very first time, the Supreme Court of Kenya will be compliant with the 2/3 gender rule requirement, because that will bring the membership of the Supreme Court to 3 women and 4 men. Also, the whole outlook of the government, the 3 arms of government, will be gender compliant, because one arm of the government will now be ended by a woman. Therefore, these principles will always be complied with. The judiciary has set the standards to show that they are compliant with the requirement of the 2/3 gender rule. For the very first time now, we are completely compliant. We have, in all the court stations, we are compliant. When it comes to magistracy, there are more than men. They are 52%. The men are 48%. But when it comes to judges, the women are 39%, and the male are more than the women. But we are compliant, and we are setting standards for the executive and also for the legislature. That's what I would like to say about that issue of Article 232 on equal opportunity. On expanded jurisdiction of the Supreme Court, this is a new court which is now 10 years old. And when it comes to the interpretation of the Constitution and the application of the Constitution, there seemed to have been a floodgate of litigation to that court, everybody saying, my judgment, which was from the Court of Appeal, touches on the constitutional interpretation, touches on an area of law that is of national, of general public importance. But the cream is coming on top now that it is crystallizing. They are very, very clear on the cases that are admitted because, of course, realizing that every case can touch on the constitutional interpretation. They have clarified and said unless the constitutional issue was in dispute in the trial court, in the magistrate's court or in the high court or in the Court of Appeal, then you cannot introduce it in the Supreme Court. Then the issue of tribunals, there are actually 6 tribunals in this country. They are transitioning to the judiciary. About 20 have already transitioned, but because of budgetary constraints, not all of them have transitioned to the judiciary. So this is work in progress that we are going to engage in, including this August committee, to see how all of them can transition and how they can be operationalized, because tribunals are important in terms of providing Kenyans with a multi-door approach to solving problems that actually crown the courts. Thank you.
Another member has come in. Honorable Kaluma, introduce yourself.
Yeah, I thank you, Chair. Chief Justice nominee, I'm George Peter Kaluma. I'm MP for Homa Bay Town constituency. I've served in the Justice and Legal Affairs Committee for 8.5 years now. I congratulate you on your nomination.
I start with Zureka, then Mheshimiwa Andan, and followed by George Murugara. Start with Zureka.
Naam, nataka kukupongeza mwanzo kwa kuwa mwanamke wa kwanza humu nchini kuteuliwa kama jaji mkuu. Na kuna msemo wa Kiingereza, bwana mwenyekiti utaniruhusu, unaosema justice delayed is justice denied. Maana yake hukumu ikicheleweshwa basi ni kama kukataza mtu kupata haki yake. Kwa hivyo kwa miaka mingi sana wa Kenya wamekuwa wakisubiri muda mrefu sana kuhukumiwa changamoto zao tofauti tofauti. Sana sana hukumu za masuala ya ardhi yamekuwa sugu zaidi. Kwa mfano wiki tu iliyopita Kwale County mji wa Mwamdudu kuna watu 250 ambao walivunjiwa nyumba zao, na wengi wao walikuwa wamejenga hizo nyumba kwa mikopo. Unajua watu wakijenga nyumba sengine wanachukua maisha yao yote kuweza kupata mali tofauti tofauti. Na hapo nyuma kwa miezi 6 kuna mashamba yamekuwa yaking'olewa miti yao, minazi, miembe na kadhalika, sehemu za Kanana na sehemu nyingi Kwale County kuna miji ya Nyari huko Samburu na kadhalika. Kwa hivyo na wakati kadhaa wananchi wamekuwa wakienda kotini kwenda kuomba ruhusa ili uharibifu wa mali uweze kusimamishwa kusubiri maamuzi ya koti. Yani kutafuta yani ule usimamizi wa haraka haraka. Lakini kuna baadhi ya koti zinaweza kuchukua hata miezi miwili kuamua usimamizi wa koti au kwa lugha ya Kiingereza injunction. Kwa hivyo wajua baada ya miezi miwili hasara kubwa itakuwa tayari imefanyika. Kwa hivyo Mwenyezi Mungu akikujalia ukichaguliwa kama jaji mkuu wa hii nchi, je, pengine utafanya mambo gani kuhakikisha kuwa mahakama zina hukumu kwa muda mwafaka, hususan masala ya ardhi, ili kuhakikisha kuwa mali za Kenya zinalindwa, na hususan mali za watu maskini ambao mali pengine ni hiyo hiyo alionayo, hana mali nyingine. Alafu pia pengine utahitaji msaada gani kama kuna haja kutoka bunge kuweza kufaulisha hili, na pengine je kwenye urais au executive kuna kitu pia unaweza kupata, unaona pengine kuna msaada fulani unaweza kupata kuweza kuhakikisha hili linakuwa. Asante.
Adan, short.
Thank you, Chair. Welcome, Madam Justice Kiome. My question is also very close to Honorable Suleka's one, that you just said that in Kenya today we have about 175 kilometers to access justice. But I know that in some areas, particularly in the far north, where 300 or 250 kilometers from where I represent actually, the nearest court is 250 kilometers. It is too expensive for both the government and those who are to be taken to court. God willing, you will win this position. But if you do, what will you make sure? What will you ensure that access to justice is as close as maybe sub-county level or constituency level or even lower? Thank you.
George, your first.
Thank you. Thank you. Welcome, Lady Justice. I have 2 questions, and these relate to your very full tray that you're going to find in that office if this committee approves, which I hope it will do. Number 1, we've been talking about corruption in the judiciary. And most of the time, we've been focusing on the judicial officers, the magistrates and judges. We know very well we've tried to slay the dragon. We've not succeeded. And we may be a bit happy to hear from you how you propose to pick it from there and proceed. But most importantly, we have to talk about other forms of corruption which are found possibly in all the arms of the government involving your administrative staff, whereby we have cases of complaints against your officers for goods delivered, sold and delivered, and services rendered, but not paid for because of corruption, demand for bribes, etc., and other malpractices. How do you propose to deal with these administrative officers? Because Kenyans are complaining about non-payment or pending bills in the judiciary. Closely tied to this is question number 2, which is stored projects of the judiciary. Another issue we have we've been dealing with for the last 4 years since I became a member of this committee, but we have made very, very little progress. All the time, lack of exchequer, etc. But most important is the wisdom in actually establishing a court room or a courthouse using wood for the last 6 years or so. And I have a case of my constituency which I can draw inference from at Marimanti, where we have a courthouse partly done, made of wood. And knowing Tharaka very well, safari hands have actually found fodder in that. How do we deal with this? Because it is common all over the country, something like misguided opportunities, projects that possibly were not properly thought out, and this is going to be in your entry. How will you handle this?
Particularly on, no, I don't want, I'll take that later. I think we are overloading her. There's a start with Wangwe on, I think, appointments in the judiciary, delayed appointments. Huh? You did? Okay. Then Anza, Zureka, and combined with Andan.
Yes. Thank you, Honorable Member, Honorable Sureka, for this observation, delayed justice, or justice delayed is justice denied. This is a shared concern across board. I think I said it in the opening remarks that Kenyans want to be sure when they come to court, how long are they going to wait for the determination of their dispute. And this is possible because you are aware, honorable members, election petition disputes are completed within 6 months. So what we need to do is look at the human resource register asset and see why this delay. Land matters are very emotive matters. This is something we are going to have a round table with this August committee to discuss issues of evictions. Do we need an act of parliament or regulations about evictions? Because they seem to disturb everybody, the way they are sporadically done, and the way they bring a lot of suffering to the people. And attached to that is also the national development agenda, that it is sometimes required that public land must be developed. So balancing those public interest matters and the rights of citizens require all of us to come to a roundtable meeting and discuss the best way. If evictions have to be effected, how do they get effected? People must be given a notice. People must be given an opportunity to move. Their human dignity must be respected. And then I agree also with Honorable Andan that in some areas, the distance to access the courts, like when I served in Kitare, and I had to get witnesses come from Rokichogio and come from Kakuma, Rokicha, all those areas, they cover more than 300 kilometers. And this requires judiciary partnering with the CDF and also with the counties to see how we can bring justice closer to the people. They do the mapping, and I think mapping has been done. When I was reading reports from the judiciary, we have identified all areas where we need to establish courts. But like I said, a court does not exist alone. It exists with a police station, and it exists with other services, other government services or county services that are rendered by the county governments. So this is a partnership that I'm going to look at very closely, working with Council of Governors and working with you, honorable members, to see how we can bring justice closer to the people. I mentioned 100 kilometers as the minimum that somebody should be able to travel to access justice. And then questions from Honorable Murugara about the entry that I'm going to find in the judiciary if I am privileged to be approved by this august house. corruption is a big problem in this country. And I look at it from a two-pronged approach. There is a perception of judiciary, of judicial officers who are corrupt, perception and real. Like you put it, there are people who refuse even to pay for services that have been rendered so that they can be given bribes. And I believe this we can work together with other organs like the EACC and the DCI and to ensure that the judiciary is free from corruption. The services that we render must engender confidence of Kenyans. We are paid to render services, and therefore no member of public should pay a judicial officer for anything. They shouldn't, to facilitate anything. And once a few of them are arrested for corruption, I believe they will stop. Then there are corruption cases that are pending there, very many corruption cases that are pending in our court system. They have not been determined. And this also bothers everybody, that these cases just go round and round and eventually they disappear. This is going to be my top agenda if I'm privileged to be approved as the Chief Justice, to make sure that we have a roundtable meeting also with the NCAJ, under the auspices of NCAJ, the DPP, the police, and all the stakeholders, and agree how these cases will move quickly. The investigations reports ready in court. The prosecution witnesses ready to come and testify. We are now embracing technology, and we can actually be able to proceed with these cases. And the same way we complete election petitions, within 6 months, we can be able to complete also these corruption cases if we all work together towards ensuring that there is justice and our country is secured and protected from corruption. This is of utmost urgency and importance to the judiciary and to this august house, and also to all the members of public. Stored projects are also a thorn in the flesh, and you actually answered it when you said it is because of rate remittance of exchequer that we have not been able to complete these projects. If I am privileged to be approved by this committee, I am going to be very concerned about the value for money. What does it cost to put a courthouse? The same cost that cost us to build our own houses, that is the same value for money that we should incorporate. And in my retail strategic plan that I am going to share with the honorable members, I have indicated that I'm going to institute, if I'm privileged to be approved, a system of ensuring audits that ensure there is value for money in all the projects that the judiciary undertakes. So these stored projects are waiting for release of money. We are aware of the judiciary fund that has not been operationalized. And when money is released late, it affects also the operationalization of the projects and delay, because sometimes the contractors have left the site, and when they return with revised bills that cost more money. Thank you.
And I think the last two should be honorable. Oh, you haven't, you need. Yes. Lesuda, Mheshimiwa Lesuda, Mheshimiwa Junet, followed by Oruoch. Yes, and number 4, Jennifer Shamala.
Thank you, Chair. And congratulations, Lady Justice, for this far. And we look forward to you being the Chief Justice of this country. And we'll be very happy that at the judiciary you'll have met the 2/3 gender rule. Mine was just on corruption, but now I'll make it a comment because it was earlier a question, but you have touched on it. And honestly, I think Kenyans are really looking up to the judiciary on issues to do with corruption and especially wastage and graft of public resources. And this continues to be a national debate on how the cases are handled. And also Kenyans feeling that the judiciary is just for the, walalahoi, the poor. Their cases had quickly and people are jailed. They say you're jailed faster if you steal a chicken. But once people are involved in billions graft of public funds and the case go on for years, and at the end of the day, what Kenyans have been treated to is a lot of blame game. The DPP saying we don't have enough evidence from EACC. EACC saying something else. The police, and then the judges themselves. And finally, there is no accountability of the resources that are lost, which are public funds. So you've touched on it, and I wanted to hear whether you think it is also important we set a time limit of when we hear these cases so that there's also justice even for those who are accused instead of being at the corridors for way too long. But I know corruption, the focus of Kenyans on you on how corruption will be handled moving forward will be keen. The second issue is that having been the president at FIDA for a while, there's this misconception, among Kenyans that FIDA is just there to defend women, it's women. But I've heard you've said something about families. And I'm sure it would be, I'd be keen to know about this discussion that has been going on about the age responsibility, especially on issues to do with sexual intercourse between, children, that is the boys and the girls, and the boys or the men are feeling that the boys who are under 18 should be treated the same way as girls who are under 18. And I'm sure they'll also just be looking at you on how some of these issues are handled. Others feeling that now we have a woman, CJ, we will have a feminist up there on how we handle our issues. It will be important to just hear your comment on that.
Junet?
Thank you, Chair. Chair, first I want to congratulate the CJ nominee. I'm happy that a lady female judge is becoming our Chief Justice. And I think that's a good step in the right direction for our country. Personally, I believe women can be better leaders than men. But I've not told my wife that, so she should not hold against me. Anyway, let me go to my question.
Point of order, Chair. Chair, Honorable Junet is our whip, and when he starts by approving in his statement, we get worried.
Yes.
I've also heard it from Honorable Lesoda. I think we keep our decision within. Because I'm now whipped.
Chair, that was just a compliment. Chair, I have one or two questions. My first question is, I wanted to ask the incoming Chief Justice that, how do you plan to hold the judiciary accountable? Madam Judge, this country, we also represent litigants in Parliament who have suffered in the hands of the judiciary. And when you complain about judiciary is known for invoking the independence of judiciary. You can't speak about them. They live in their own world. You say something about them, you are in trouble. There are problems of delayed judgments, miscarriage of justice, misconduct of judicial officers, and there are many cases pending at the JSC which require either disciplinary action or tribunal. There are many issues that you need to handle. So how do you intend to hold the judiciary as the leader of that institution, to hold them accountable? My second question, Madam Judge, is how will you handle the pending 41 judges that have been refused to be sworn in? Because now if you become the leader of that institution, what do you think you will do that will make sure those judges are sworn as approved by the JSC? Or what mechanism do you want to put in place to break that stalemate? Because that stalemate has appeared before this committee many times. My last question is, you have led many, you had held many leadership positions, both in judiciary and outside judiciary. Some of them were in the civil society. And the civil society has done a lot of work for this country. Part of the democracy that we enjoy in this country today was achieved through the civil society. And while you are also the chair of FIDA, I can tell you, when men used to hear FIDA, they can pee on their pants. They used to fear FIDA like something else. So now, how are you, and you know, the civil society is known for believing in idealism, ideal situations. But sometimes when you are in a leadership position, that might not be the point. For example, the civil society, you know, they advance, for example, the protection of LGBT community. For example, our constitution maybe is debatable, religious issues. How are you going to balance those differences in the society as the leader of the judiciary? Thank you.
Shamala? No, let me get, you want to go after? Yes, Shamala?
Lady Justice Martha Koome, should this committee and the National Assembly approve your nomination, you will become the most powerful woman in this country, heading one of the 3 state organs where all sovereign power, of which all sovereign power is delegated to. I think, and definitely judges don't come under the public scrutiny that politicians do and the executive does. Who is Martha Koome the person? Who is Martha Koome the family woman? Ultimately, how would you want Kenyans to remember your tenure if you are approved and your legacy for the judiciary?
Ruch. Mheshimiwa Ruch.
Respond to those 3, but I can ask.
Yes.
If that's okay. Okay, thank you very much again, Lady Justice. I'm going to try and engage you on 2 issues. First of all, on your judicial philosophy and jurisprudence, and secondly, to engage you on your understanding on a few principles. And I understand this not in the context of re-interviewing you, but so that you use this as an opportunity to give us your, judicial philosophy and how you will guide this ship. And I want to begin by reading to you a very brief paragraph by Professor Githu Muigai, former Attorney General, in an article he wrote, Political Jurisprudence or Neutral Principles, another look at the problem of constitutional interpretation. And briefly, what he says, among other things, is that the jurisprudence of the constitutional interpretation in Kenya is in dire need of rejuvenation. So I have bracketed there, do you agree? And then he goes on to say, in formulating principles of constitutional construction, cognizance must be taken of the fact that both pro-neutral and anti-neutral principles agree on some fundamentals. And then I've bracketed there, are you familiar with what Professor Githu is referring to neutral principles, and are you pro-neutral or anti-neutral in the construction on constitutional interpretation? Finally, he goes on to say that, fifthly, the judicial role is a political role, and therefore the judiciary is a political actor within our democracy. And then I have bracketed there, do you agree that the judiciary is a political actor within our democracy? If so, why? And if not, how not? And then in conclusion, he says, complex constitutional disputes involve balancing competing interests or claims and invites value choices. So the last question there is, what is your understanding of how you would go about balancing competing claims in complex questions, both political or otherwise, and what is your understanding of value choices? I have another which I will allow her to answer, and if time permitting, later I can ask, but I want to allow her to respond to this. Thank you.
Okay, you go for take those. Judge.
Yeah, thank you very much for those questions, honorable members. I think from Honorable Resunda, it was a comment about corruption, which is a shared concern, what we can all do to make sure that cases involving corruption are expeditiously dealt with so that Kenyans can move on. And what I would need to emphasize is that we can strengthen the National Council on the Administration of Justice. And I mentioned that we can have an act of parliament that actually gives powers and mandate to the NCAJ to deal with these matters that require interdependence and require us working together, because no one of those bodies will be able to deal with the corruption without the other. Even if the judiciary is so efficient, if the police are not, if the ODPP is not, we cannot deal with corruption. And then about the family, you asked a question, and a judge is always very shy and very cautious to express themselves in matters that may come to court. But when it comes to the age of criminal responsibility, the law is clear that anyone under the age of 18 is a minor. So even if it's a boy who has committed an offense when he is under the age of 18, we treat them as a child in need of care and protection. We recommend them to be counseled, and we are also, and even from a child rights defender, I would not recommend lowering the age of sexual responsibility, because already, you know, we are battling with early child marriage. We want our children to be in school, and there is no hurry to lower that age, which is internationally recognized as the age of responsibility, 18 years. And the other question was from Honorable Junet about making the judiciary accountable. It is in the Constitution that the power that is given to the judiciary, the judges, judicial officers, we are accountable. We are accountable under the Constitution. We are accountable under the Leadership and Integrity Act. We are accountable under the Code of Conduct, which this August committee passed recently. And we are bound to be accountable in terms of our time. When we come to work between 8 and 5, we must fill in a form to show what it is that we did. If you have delayed judgments, then you are supposed to explain to the head of the division or the head of the court station why the judgment is delayed. So I agree there are some cracks, because we have cases that have been pending for many years, but those are administrative issues to be handled. There are instruments already in place that require very serious accountability. The problem is the implementation. And you asked about the pending case of 40 judges who have not taken office, and this has affected the human resource register capital. Like the Court of Appeal where I sit, we are just on the threshold. The Constitution requires that we should not be less than 12 judges of appeal. And as I sit here, we are almost there. So it is of utmost urgency that these 40 judges are sworn in office. So I will negotiate, because like I said, I have very good negotiation skills. If there are problems with some, that problem can also be sorted out, because if you have a problem as a judge, it must be sorted out one way or the other. Then you have asked the law of the civil society. You have commended them for doing great work, especially in the struggle for democratization and good governance. And I think they continue to fill the gap whenever there is a gap, even in representing people who cannot afford legal services and looking at the vulnerable groups in the society. So they play a critical role in our society to ensure that all the vulnerable groups, their human rights, their human dignity is protected. And Honorable Shamala has asked me to comment about what am I going to bring at the table as a woman leader. I'm just going to bring excellence. I'm just going to bring commitment in the delivery of service, because this is what I have done all these years. When I sat in Nakuru, we started the court user committee, bringing the stakeholders at the table so that we could discuss and find solutions. And at the end of it, I'm going to ensure that there is access to justice. I was instrumental in starting mobile courts in Kakuma and in Lokicha, and we will continue to make justice accessible. And at the end of it, I would like to be referred as a champion for justice, one who made the judiciary an efficient institution that engenders the confidence of Kenyans from all walks of life, achieve justice for all Kenyans, children, men, business people, improving commercial court and access to justice also for business people, so that their disputes can be finished quickly. And the last question was, what is my judicial philosophy? Before the Constitution of 2010, we were struggling to understand or to ascribe the judicial philosophy of each judge. I think then I was a liberal, progressive jurist because my judgments are progressive. But now, thanks be to the Constitution 2010, the principles that we embrace in interpreting the law are all provided for in the chapter, in Article 10, in 232. We must be progressive. We must look at this Constitution as if it is speaking. We must look at this Constitution as a document that is alive, that we should breathe life to it all the time. So the questions the Honourable Member asked me are very difficult to say whether they are correct or not. I'm just there in the middle to say that in every interpretation that I do, I am guided by the Constitution, and the Constitution is progressive, it is liberal, it emphasizes on respect for human rights, human dignity, and where one is able to realize their potential. And every judgment you deliver, you are supposed to ask yourself how it affects the persons, the children, the women, the men, the political class, and everybody. So that is how I would answer that question on judicial philosophy, that it is founded. The principles are all founded in the Constitution of Kenya 2010, and we can name 159, we can name the chapters, the articles that provide the interpretation principles. Thank you.
Very well, Judge. Honorable Vice Chair.
Thank you very much. I was waiting in the queue. But now I have to be served last because I'm Vice Chair. Honorable Lady.
Then let Kaluma then go.
You want to go ahead of me?
Yeah, Chair, because of ranking, maybe I use this occasion to say why, under our standing orders, for the first time during vetting, I'm not going to put forth a question. Okay. The CJ nominee has mentored my wife who works in the judiciary from the days she was in FIDA to date. Now, because of that, we consider a family friend. I'm not going to put any question.
Very well.
CJ, there is also a compliment we have on record from the CRADO, which is the Children's Foundation run by the Honorable Millie Grace Akoth Odhiambo. Millie is my niece. Because of that also, I will withdraw. So I wish you well. I wish you well. Thank you.
TJ.
Thank you, Member for Homa Bay. Lady Justice, I have just follow-up questions, supplementary questions, because many of us have literally asked perhaps everything that could have been asked. Maybe just to reinforce so that the nation hears you very clearly on some issues. You know, Article 245 of the Constitution mandates the Judicial Commission to report at the end of every financial year certain things to the President and to Parliament. Now, your predecessors took a rather condescending attitude towards the. I know the member for Suna wants me to continue to suffocate.
Is the member asking as the vice chair of the committee or as the People's Chief Justice? Which title are you using?
Yeah, you see, I'm already in office even when we are looking for the Chief Justice of the Republic of Kenya, but the People's Chief Justice will always be there. Yeah, so your predecessors took a fairly dim view, I must say, about Parliament or the legislative arm of government in terms that they felt they would not oblige to the jurisdiction of Parliament. I remember in one hearing of the Chief Justice Willie Mutunga and the former Chief Justice David Maraga, he said that as the head of the institution, he cannot come before us. He cannot come and sit where you are sitting before a committee, because that therefore lowers the dignity, or what he perceived as the dignity, of the judiciary. And so what he did would be to, both of them, would be to continuously send the registrar, to interact with us. Now, whereas the registrar has a function, administrative and the secretary to the commission, but the president of this republic, being the head of the executive himself, comes to Parliament and addresses Parliament on various issues as mandated by the Constitution. Do you consider yourself to be in this school of thought who thinks that merely interacting with the legislature is an affront to the dignified stature of the judiciary in terms of Article 245 and so on? That's number one. Number two, I've just recaptured what I had one of my colleagues ask you about your relations. We want you to be very specific how you will relate with Parliament, both Senate and the National Assembly, without, of course, lowering the perceived dignity of the judiciary. Number two, I've had a chance of reading as many of the decisions as I could get. And you are very strong on family law. And you have postulates, your jurisprudential postulates are very firm and some of them very interesting. One of them is what I find controversial as jurisprudence on patriarchy. You find many of the laws in this land are designed, so to speak, in what you call are designed in a patriarchal basis. And that is the substance of one of the people who have written to us in opposing your appointment, a gentleman called James Kamuthi Kibunja. In a case which you did, and that case you are familiar with because it has been coming up, and it's a case of custody, child custody. The problem, the concern, what is disturbing is that you handle that case without hearing the father of that child. You did not hear, you heard what lawyers called ex parte. Now, I'm putting that together with the issue around gender, right? If you become the Chief Justice, the office of the Chief Justice and the office of the Deputy Chief Justice will be from one gender. Now, I want you to speak to the other gender, not your own. Do they have a cause of concern? You seem not to have found value to hear the father of that child. And you will be two members of one gender. And you have been very strong when you were in FIDA or in the civil society before you came to the judiciary on matters pertaining to women's rights. Would you consider yourself, this is very fair, would you consider yourself a feminist? And do people of the other gender have anything to fear in your leadership as a Chief Justice? The last one is this, that you are older than me, but fairly young. If you are appointed the Chief Justice, you will be around for some 10 or so years if God gives you the health. And you have, you know, what Honorable Member for Mathare has been asking, you have made certain positions in your jurisprudential outlook. Do you think, in terms of expansion of jurisprudence, in terms of expansion of knowledge in that area, Kenya would be saddled with some of your jurisprudential outlook? For the next 10 years or so, we'll have to live with your views about certain things. In terms of expanding our jurisprudence, how does that sit with you?
I think you want to add? Yes,
yeah,
but
no, I just want to put, you know, he's a lawyer. He has put it in legal. I want to put it plain to the judge.
No,
this House of Record is good. You dispense it off with it once and for all. There is talk and rumor that you are a feminist and you hate men. Please clarify that.
Just the same.
Let us try. Yeah, I will allow you, but let us try to cover. If something is covered, let us not delve on it too much. Yes? Let us hear you, Mheshimiwa Kamote.
Yeah, Chair, as the judge addresses that, maybe she can, maybe in one line, give us her personal conviction on same-sex relationships.
Yes.
Thank you very much, honorable members, for those questions. I will begin with the interaction and the collaboration between the judiciary and this august house. It is true, every year the judiciary has to submit a report the State of the Judiciary report is submitted to the Parliament regularly. But I noted when I was preparing for this interview that there are no rules or guidelines on how we do the follow-up on issues arising, because in every report there must be a review of what needed to be done, especially where we need collaboration. So this is something that in this roundtable meeting we are going to discuss. I recall Chief Justice Emeritus Dr. Willy Mutunga called the Senate, and I think also a meeting with the National Assembly. The committee met with the judges to discuss the challenges that we face. If I'm privileged to be approved by this August House, my role is to implement the Constitution. I'm a mere servant of the Constitution. What the Constitution says I should do, I will do. If the Constitution requires me to appear before this House, and we will discuss that at the round table, I wear power very thinly myself. This power is exercised on behalf of the people of Kenya. This power is exercised for the best interests of Kenyans. If it requires me to come and sit here and answer to this august committee some issues, I will do that. If it requires us to sit in another setting, which is a roundtable meeting, we will do that, because we are doing it all for the best interests of the Kenyans. And then the question was, I have decided many cases where I have declared rights for men. One case that stands out is a father who wanted to throw out his 5 sons from his shamba, because he said they are grown men, they ought to have their own places. And I refused, I dismissed the case. So I am a judge who looks at both men, women, children, the society at large, and Kenyans who feel very safe. If I am privileged to be confirmed, my appointment to be approved by this august House, I can state publicly that I follow the dictates of the Constitution, of the statute. I can never operate outside the Constitution. I do not hate men. As a matter of fact, I've been married for the last 5 years. I got married when I was very young. I went to the University of Nairobi when I was already married, so I know how difficult it is to balance a family and balance education. But I'm so proud that I graduated with a daughter. I graduated with a husband who has remained my dear partner and compatriot all these years. So I support families. All my life, I have worked for families, because I know the family is the background of the society. And if we protect the family, then we have protected the whole society, because those people leaving the family will be empowered to go out there and make a living when there is no violence in the family, when there is only encouragement and love in the family. If I'm approved, I hope to use this power of convening as the Chief Justice to speak to the families that we need to bring up our children, we need to protect our children, we need to empower our...
Point of order, Chair. I didn't wish to interrupt the Lady Justice, but you know this is a public forum, and is it in order that members twice foot thump a member that they are actually interviewing? This is a public interview. So I think I wanted to ask whether that is in order.
I says,
if she's giving the correct answers, what do we do?
Well, it has not. Mheshimiwa Oruoch, I've also had applauded you when you asked your question. So don't worry about this. It's a small affair. So thank you very much, Judge. Are you through?
Yes, I was.
Okay.
Thank
you. Thank you very much.
About jurisprudence, and she's going to be on the bench for 10 or more years.
Yes, yes.
Are we going to be
May
stuck
I comment on
with
that
your...
later?
Yes.
Can I comment on that later?
Yes, sorry, I didn't comment about jurisprudence. Jurisprudence grows every day, depending on the facts that are and the evidence that is brought to court. This is a very, very progressive constitution that embraces also international law and international human rights. So the fact that I made a decision yesterday this way cannot worry anybody, because we are always persuaded by the case as it comes. And the Supreme Court, if I'm privileged to be approved, where I sit, we are not even bound by our own decisions. The Supreme Court is supposed to always look at the law as if it is growing every day, the circumstances and the exigencies of the matter all the time. Therefore, my jurisprudence, which is progressive, should not worry anybody, because it will continue to grow.
Chair, I had reserved a question. If members are through with their line of questioning.
Let us not keep asking questions, Mheshimiwa Kamote, in piecemeal. Let's hear the last comment on the reserved question by...
Chair, can I have mine?
Yeah?
Can I have mine? Chair,
fine,
Chair.
I will allow you, or let me start with Aruoch, then come to Aruoch, then go to Kamote.
Did you say you start with Oluoch, then Aluoch, or vice versa?
No, you are neighboring. I am starting with Aruoch. No, okay. No, wait. Just wait, because your mic is on. That is why.
Okay, thank you, Chair.
That's why, and then go to Aruoch, and then go to Mheshimiwa Kamote.
Thank you, Chair. Chair, in Parliament, many times the judiciary comes under attack. Some members sometimes criticize judgments, criticize judges, individually, personally. And some of us know that that's not proper. We try to defend the judiciary many times, so that if they need to be criticized, we do so in the proper manner provided for by law. Sometimes there are utterances that come from the judiciary about their frustrations. We hear those. Where I sit when I hear members of Parliament criticize the judiciary irregularly, or the judiciary busting also irregularly, then in my mind I see that there is lack of proper nexus on how the judiciary can make use of this committee to air their frustrations. And it's something that I think Justice Kome will deal with, being, like me, experienced in mediation and arbitration. But it's something that needs to be looked at by the judiciary, how you can use this committee to air your views and get what you want. Now, Chair, second, that aside, national ethos that are enshrined in the Constitution 2010, and which I think Justice Martha Koome did not be reminded about, is cohesion, national integration, and regional balance. These are in the Constitution. Justice Koome, does it bother your conscience that if you are recommended by this committee and approved by Parliament and appointed, then all the three organs of government in our great republic will end up being led by persons coming from one region commonly known as the mountain? Does it bother you?
Thank you again, Chair, and thank you, Lady Justice, for your first question. I had separated my two questions, and I did so advisedly so that I would give you the opportunity to deal with them with some considerable detail. And the reason is that other than what Honorable member for Ruaraka has mentioned that the nation is listening and they want to hear. The legal scholars are also following this with considerable interest to see how they can find comfort that a person who will expand jurisdiction and their practice is going to occupy this position if they do. And so I wanted to make this follow-up question again, and I had a preamble to this, which you have said about your involvement in the civil society, and then of course you've been a judge for a number of years now. That makes you an insider-outsider. When people are being interviewed, there was the argument about are they looking for an insider or an outsider. So allow me to call you in this respect insider-outsider. So in this insider-outsider outfit, would you call yourself one leaning towards judicial restraint or judicial activism? Then my other question, in very brief, I just wanted to refer again to an excerpt by Dr. Willie Mutunga, former CJ, in an article he wrote, the 2010 Constitution.
Sorry, point of order, Chair. On these interview questions.
Just allow me, please.
Okay.
Comments
all right.
And,
with all respect.
Just, yeah?
Okay.
We allow comments or... Yeah.
But they see they're not comments, they're questions to the jurisprudential questions to the nominee.
Either way, let's allow him.
With the utmost respect, I looked at the short guide that was given to us at number 17 and 23, speak to the question, what is her judicial philosophy, jurisprudence, inclination?
Don't worry.
And I think I'm perfectly within, just allow me to
make your comment.
Thank you, Chair. And so, Chair, Dr. Willie Mutunga, in that article, the 2010 Constitution of Kenya and its interpretations, reflections from the Supreme Court decisions, he said this, and I will be very brief about it. Fifthly, that's what he said, what I want to emphasize here is the need to develop a new, not only highly competent, but also indigenous jurisprudence. I link this last adjective to the constitutional values of patriotism. I conceive that it requires the judge to develop the law in a way that responds to the needs of the people and to the national interest. I call this robust, rich, indigenous, patriotic jurisprudence as decreed under the Constitution. So the question that I wanted to say is that, the former Chief Justice makes a case for an indigenous jurisprudence. Do you have or think there is a uniquely Kenyan jurisprudence, taking account that, after 2010 we went away from common law? In the last 10 years, have we crystallized any kind of indigenous jurisprudence that is uniquely Kenyan? And if not, where are the gaps? Where would you locate those indigenous jurisprudence? And if there are gaps, what would you do to try to fill that gap? And then my last comment is one sent by a constituent in relation to the Judiciary Fund. I believe this was George Solowaga Kinyi. He said, ask the CJ nominee if she is aware that the judiciary account opening forms for the judiciary funds have been sat on by the governor for the last 1 year. I'm not so sure about the factual dispositions, but that is a question that has been sent to me. And thank you very much, Chair, for the opportunity.
Well, Kamote, last. I hope this is the last.
Chair, it's just a follow-up of what I elicited from the judge. And my reason for asking for her conviction, personal conviction, is that Kenya is not living in, we are not in isolation. And bearing in mind that we are bound by international treaties, right now we have so many organizations in Kenya who are championing for these same-sex relations, and some go on putting billboards on our big roads. So it is crucial to know the head or the conviction of the person whom we intend to put at the head of this.
All right.
Thank you.
Answer those. I think those are the last questions.
Yes, thank you very much.
You want to...
I just, as a rider to those two questions that were asked, Perhaps the nominee can answer it and I want to thank Honorable Anthony Alot for the question on indigenous jurisprudence vis-a-vis international law and international norms, and in which our Constitution says that they will become part and parcel of our laws. But having stated that, and what Honorable Kamoti has asked when it comes to certain thinking or ideologies that are not in tandem or in the ethos of our nation, how would the Honorable Chief Justice handle that? And thank you, Honorable Awad, for bringing up that question on indigenous jurisprudence.
Yes.
Go for those.
Yes. Thank you very much. The question that Honorable Argoch asked is how we can continuously liaise for the interest of this nation between the judiciary and the National Assembly or the Parliament, because when judges are criticized, then we lower their, their estimation or the dignity of the court or the dignity of the judiciary to the members of public. And this has an impact in the way we respect the rule of law. So I can only agree that we must continue to work in complementarity. One hand cannot fight the other hand. We are all serving Kenyans, and we need to always have this round table meeting. If there are issues, we discuss issues, because this is our country. And if there are problems, it is only us who can solve those problems. Then the member asked about the national ethos of cohesion and national integration, the fact that the three arms of government will be ended by people from one region. What I would like to say, honorable members, is that I come from Meru County. That is where I was born. My ethnicity is Meru. I did not choose to be born there. But for the 33 years that I have worked, I chose to serve Kenyans. I opened my law firm in Nairobi. I joined the Law Society and we participated in the constitutional making. I acted for pro bono clients from all corners of this country. I was the lawyer for the Right Honorable Raila Odinga when he was detained without a trial. Mama Aida came to our office when I was a very young lawyer, and when she shared her story with me, I took up the matter and made representation to the detention committee then. So I've served Kenyans from Marindi to Rokichogio, from Nyeri to Milimani, without caring whether they come from this region or the other, without caring about their status, and Kenyans feel safe in my hands. They don't ask me whether I come from Meru, therefore I should not render service. When it comes to appointments, the Constitution is very directive that you should zero in on competition. I competitively applied for this position, and I mentioned that I started it in 2011, 2016, and managed to become a nominee in 2021. So this is a competition. I went in and competed with the others. Then there is merit. I was also considered on merit. And then the third criteria is gender. And when it comes to the other three arms of the other two arms of the government, it is male from number 1 to maybe 10. And even when it comes to this august house. So it is for the very first time the judiciary is becoming compliant. And the other thing I need to mention to the honorable members, I think, which is also like a judicial notice, is that these offices are transient. Whoever is the end of the executive now may not be in the next 1 year and a few months. Well, I don't know, but that's what we call judicial notice. So I serve Kenyans with absolute commitment from the depth of my heart and my gender or where I come from does not come in my way. And then there was the question of the legal scholars. My philosophy, I said my philosophy is derived from the Constitution, which is very, very progressive. And this Constitution enables us to create indigenous jurisprudence, which we can even export to the other regions. I use a book written by the Honorable Karuma when I'm dealing with the judicial review, because he has explained how we can expand beyond the common law principles, which required us to just deal with the four corners of Madema, Certiorari, and prohibition. But now with our Constitution 2010, we can go beyond that to deal with issues of proportionality and legitimate expectation. So this is the indigenous jurisprudence that we are saying is Kenyan grown, because it's beyond the common law that guided us for all the years since independence. And we have a lot of room to grow this indigenous jurisprudence when it comes to our own unique issues of land and other unique issues of even how we deal with our criminal justice system. There is a lot of room for that. And then about same-sex marriage, I'm also guided by the Constitution. The Constitution clearly says a marriage that is recognized in Kenya is one of two consenting adults of opposite sex. So same-sex marriage is not allowed by the Constitution, and there is no way we can introduce it in any judicial craft. However, there is a case, I think, that has been cited where the High Court around a group called LGBTIQ to be registered as an NGO. And also, the High Court was found that you cannot discriminate Kenyans and deny them rights by virtue of being Kenyans. All they wanted was to be registered as an NGO. And some of the issues that were discussed there, and I'll be very guarded because this is also a live matter that is not being completed, is matters to do with intersex. We know the plight of intersex. They have both genitalia, but they don't have services, they don't have facilities where they can, like those who are in boarding school, or those who are in shared facilities, those who are using public toilets. They wanted to create awareness about who they are and their problems. And therefore, looking at Article 27 and looking at Article 159(2), that you are not supposed to discriminate against anybody on the basis of their status. The judgment of the High Court could not be faulted. We could not find any way of disagreeing with the High Court that these people, because they have not committed any offense, and as a judge you cannot assume they are going to commit an offense, cannot be denied the registration. But same-sex marriage is provided for in the Constitution. It is not allowed. Yes.
Judge, I think members. Yes, and time now.
I'm sorry for coming on this. I didn't intend to, but this can't go, I think, in my mind. Lady Justice, how do you intend to protect judiciary from what has become commonly known as revisit to the judiciary? I'm sure that is in it's in public knowledge about we will revisit. How do you intend to protect the judiciary from that notion?
Thank you, Honorable Member, and I still return to the Constitution that guarantees and secures and protects the independence of the judiciary. No one can take it away. No one can interfere. No one can tell judges how they are going to decide cases. That is written here in the Constitution. And if I'm privileged to be approved, I think we can even make it into small booklets to say this is the independence of the judiciary. These are the no-go zones that are already safeguarded in the Constitution. And if anybody tries to do anything that is against the Constitution, they know very well they are contravening the Constitution, which is not around. When it comes to interdependence, we will also sit at a round table and agree the areas of interdependence so that when the Chief Justice is seen having a cup of tea with His Excellency the President or the speakers of the august houses, it is not that we are discussing a case. We are discussing the administration of justice. We are discussing access to justice. We are discussing funding for the, which is a shared responsibility. Thank you.
Happily, we come to the end, Judge. Members have expressed their concerns, questions, and comments. Let me summarize before I give you the chance to give the last word. Let me state this on behalf of the committee, and we wish you well. In case the committee and the House approves you and recommends your appointment, if that happens, then on top of what Mheshimiwa Vice Chairman said, do your best to salvage and reclaim lost glory in the judiciary, improve relations with the other arms, particularly the executive. Do not shy from espousing and developing jurisprudence. Let cases of lost files come to an end. Perhaps take you from median jurisdiction and other progressive jurisdictions on eliminating an unnecessary pretrial procedure, go to the subject rather than rules which, as Madan said, are maid servants for the substance. And then a matter that was, this I can't remember the honorable member who raised it about Parliament and relating to Parliament. I think is Aroch? Yes. Mheshimiwa Aroch very respectfully raised the issue of we've not seen any Chief Justice address Parliament. Yes, you raised it. Become very innovative. Very innovative. Diarize like the head of state does. Make a date with the Parliament to give state of the judiciary speech so that you openly espouse and express any concerns that you may have, because consequent upon that address, Parliament to debate your concerns and express itself on behalf of the people of Kenya. With those remarks, Judge, I hope we have covered all the important material areas. And hopefully, if you succeed, then perhaps this becomes a case study for future approvals. Thank you. I invite you to make your last word, give your last word on this.
Thank you very much, Chairman, Sorry. Thank you very much, Honorable Chairman and Honorable members. I am very, very grateful for the way you have treated me. You have treated me very, very kindly, and I'm very, very grateful for that. I take this opportunity also to wish our Muslim brothers and sisters Eid Mubarak as you celebrate this great day. I've taken the comments very well, the comments summarized by the chair. I've also shared with you my submission. As a good lawyer, whenever you go for a hearing, you prepare your submission, what it is that you want to do for the judiciary. That retro booklet as my vision for the judiciary, and a little strategic plan of how I would go about implementing the strategy for the judiciary. And it is something I've always done when I took leadership positions in the judiciary. Wherever court I was the presiding judge, I would develop a small vision and a small strategic plan on how I would deal with the challenges that are ahead. So thank you very much, and God bless you.
Members, please don't leave. Members, I request you to, unless you are going to clean your hands, we have a few minutes. Housekeeping. Thank you very much.
Chair, thank you.
Okay. Very well. Very well, members. Yeah, can we? Yes, members. Not members, if you can allow us to have a housekeeping.
Just visit this.
Yes, I'm also visiting.